This particular video will be dealing with the differences between admissions and confessions. So one of the difference could be in terms of admission, when more than two accused, when more than two offenders are there in a particular case, if a person admits or makes an admission, it is only binding on him only, not the co-accused. But in case of confession, is binding on all the accused. So that is one of the major differences between admissions and confessions. And admission given by agent is binding on the principal because the principal only authorizes the agent to do a particular act. If agent itself admits something, it will binding on principal as well. And in case of partnership firm, when more than one person is there, an admission that is made by one partner will bind other partner as well. And in terms of pleader and client relationship, when whatever the pleader says before the court, before a judge, is binding on his client as well. That is to say, when a pleader makes a plea of guilty that my accused is not an innocent, is guilty. When the pleader says such statements, it is binding on the client as well, and the court can give conviction solely on based on that. And it is a general rule that admission that is given by a person will only bind on him. That is a general rule. And another general rule is that admission that is given by a person who is not a party to a suit is not relevant. Like a third party comes up and says that he says something, he admits or he makes an admission, and he's a third party. In fact, he's not the party to the suit. So here, even though he's a third party under section 18, it becomes relevant. Whatever is said by the third party is relevant. So that is an exception. Section 18 is an exception for this particular general rule. So basically, the main difference between admission and confession is that whenever an admission is made by the co-accused, it is not it is only binding on the maker, the person who makes the admission. But in terms of confession, it is binding on all the accused. That is one important point to remember. And there are two types of admissions: judicial formal admissions and extrajudicial informal admissions. Whatever is given before the court, that is formally given, are judicial formal admissions, and whatever is given outside the court proceedings could be before the family members or friends, everyone, that will be termed as an extrajudicial informal admissions. So generally, whatever is given before the court, those will have more reliability and the court will consider the same. But extrajudicial informal admissions will be used as an estoppel against the person who is making the admission. It is not let alone. And sometimes when a person is silent, it is not generally accepted as an admission. But if the court questions me and put forth certain questions on me, like what you have did and why you have did, when the court asks me certain questions with regard to my offense, when I be silent, when I don't speak anything, in such case, when I have that obligation to answer, when I don't do so, in such case, uh, it will be considered as an admission. Like I'm not speaking anything. I should speak, but I'm not speaking anything. In such case, the court may presume that I have committed the offense, and in such cases, the court may convict me. So that is what it is given here. And against whom admissions may be proved. So generally, self-serving admissions are not relevant. Like I'm saying before the court, I did not do anything. I'm an innocent person. I'm admitting something in my favor. So those admissions are not relevant. So this is the general rule. Self-serving admissions are not relevant. But whatever I say, I confess. Like I did this with this intention. I did this to a revenge. When I say something that will incriminate me or it may self harm me, that statements that I'm incriminating myself before the court will be relevant. But there is exception for this general rule as well, that is self-serving admissions are not relevant. In these cases, even though they are self-serving, it will be relevant. First is dying declaration. So it is a situation where a person says something before dying, right? So generally it is construed as whatever he says before his death will be true. He will be pure while saying that. So that is an exception for this general rule. And second would be with regard to statements with regarding state existence of any particular state of mind, body, or conduct. So whatever is that state of mind, body, or conduct, that will be relevant even though they are self-serving admissions. And another other point is that whatever that is, the other things that are relevant under the head of relevancy in this particular act, all these things will be relevant. The statements are relevant. All these statements are relevant even though they are self-serving admissions. Section 20 deals with the general rule that oral evidence cannot be given for proving of contents of the document. So, if there is a document that is in issue in a particular case, I have to prove it only through documentary evidence, right? I cannot prove it through oral evidence. That is the general rule, but there are certain exceptions. For example, if a person is entitled to give secondary evidence under section 67, 65, right? 65 of Indian Evidence Act, I presume. If the person is entitled to give secondary evidence, in such case, he can give oral evidence to prove the contents of the document. So these are two exceptions that is given to this particular general rule. And when the genuineness of the document itself is in question, in these two circumstances, oral evidence can be given to prove the contents of the document. And then comes section 21, communication without prejudice. So, in civil cases, when parties themselves agree to a particular arrangement that I will not bring this particular evidence to the court and I will not present this evidence to a court before a judge, if there is such agreement between them in a civil case, the court will consider that agreement as valid and it will not entertain evidence regarding that. So, that is given under section 21. And this provision does not affect the privilege that has been given to attorneys under privileged communication. Section 22 deals with any confession. This is very important provision. So any confession that is given on inducement, threat, or promise, right? And the confession has been made by the accused. In such case, that confession will not be relevant. It is important to read this case law. Very important. Satbir Singh versus State of Punjab. In this case, there is a post office clerk, and he would have committed theft and allegations were put forth on him, and police officers during investigations have told to the police post office clerk that if you tell me, if you confess everything what happened, I will not take any action against you. The police officer said or made such promise to the post office clerk, and the post office clerk had given confession. So in this case, it was held that the confession given by post office clerk is not relevant because the police officer had made a promise that he will not take against any action against him, and therefore only after that confession has been made. So here in this case, it has been confession has been sought on a promise, so therefore this particular confession will not be relevant. But any confession that has been made by any moral influence, in such case it will be completely valid. For example, I am confessing uh, due to some moral influence, like someone says that I will not be happy in my life, I'm a bad person, whatever, whatnot. If someone says to me like that, and with that influence, uh, with my light-hearted ability, like I will confess everything. So due to such moral influence, if I confess anything, that will be completely valid. And any confession that has been removed, like threat, promise, or inducement, due to that any confession has been made, it is not relevant, we saw. But after removal of the all these, like no more there is threat, no more there is inducement, there is no promise involved, even after that when I make confessions, those confessions will be completely valid. And there are certain situations when, in terms of deception, promise of secrecy in confession that has been given in drunken state, or there is no need to give confession, but a person proceeds to do that, and there has been no warning that has been given to person, like, uh, you don't have to do this confession because it can be used against him. If such, even if such no warning as such has been given, under these cases, the confession will still be valid, right? Even though it is a deception, even though it is a promise of secrecy, even a confession has been given in drunken state, in all these situations confessions will be valid. Or according to section 23, any confession, regardless of the custody, any confession has been given to a police officer, whether the police officer has the custody of the accused or not, such confession is not valid. But this provision does not apply to special provisions that has been made by the parliament, for example, Tadar, Pota, or Prevention of Terrorism Act. Any special acts that has been made especially to prevent terrorism of such nature will not apply to this particular provision. So generally, the general rule is that if I give a confession to a police officer, it will not be considered valid. But under clause 2, if a confession has been given to a police officer in the immediate presence of the magistrate, so here the magistrate is here, so there is no need to, get afraid of. If any confession is given before the magistrate, it is relevant. So under this context, under this provision, the term police officer includes not only, it is not only restricted to police officers, just like that, it also includes village headman or home guard, but it does not include customs officers, railway officers, etc. So we can come to conclusion that the term police officer here is not only restricted to traditional police officers. So the persons who have power to investigate, arrest, or file a charge sheet and report that before the magistrate, when any person has all these powers, they'll come under the definition of police officers and under this provision. So if I give a particular confession to police officer, the confession is not a guilty confession. Like, I'm saying a particular thing, like I'm hiding some weapon somewhere, and I'm saying that you can just go there and pick that weapon that is there. If I say, if I confess like that, the police officer rushes there and finds some evidences with that regard. So confession of such nature will be relevant to the extent of discovery of facts. Okay, it will not be relevant more than that. Very important case is Pulikri Kotaya versus Emperor. In this case, what would have been happened is that a person would have gotten murdered, and the person who committed the crime tells to the police officers that I have hidden a particular material object somewhere. He says the location, police officer goes there and finds the weapon. So with the assistance of the statement that is given by the confessor, any material has been discovered which is related to the crime. The confession will be relevant to that extent, to the extent of discovery of facts, not beyond that. And section 25 says confession will not be taken as it is, and the conviction or acquittal will not be solely based on that. It always must be corroborated. To generally put, confession is a weak type of evidence. And admission that has been made in a plaint, in a civil suit, I guess, has been admission has been made in a plaint. Such admission that has been made in a plaint shall be used as an evidence in other suits as well. Okay, and according to section 24 that we discussed earlier, confession of co-accused will also be binding on other accused as well. So that is the difference that we saw. If a confession has been made by one co-accused, will bind the other accused as well, but it is not same in the case of admission. But there is a caveat to that: both must be jointly tried and for the same offense. it is noteworthy to discuss about accomplice provision under this act. So any confession that is given by accomplice is not worthy. Okay, because firstly, accomplice is a person who is involved in that particular crime. We cannot get confession solely from him. He's a criminal accomplice first of all. So whatever he says must be corroborated with some other evidences, and retracted confession is something that we have to discuss. If if a confession has been made in the morning before the court by a person, and the same person says something else, right, in evening, both are not related. Whatever he said on morning is different from what he says on evening. He's retracting from his stance. So uh, we cannot rely on such confessions, but when they are corroborated, they can be relied. Even retracted confessions, even though their reliance is so much less, they can be relied once they are corroborated. So that is what given under these provisions, under uh, which are under confessions and admissions topic.